I'm in charge of the litigation and dispute resolutions in the firm in ADCO, and in dispute settlement, we do handle here not just litigation, not just court litigation, police complaints, and so on. I also in charge of the alternative dispute resolutions, arbitration, mediation, and so on. I'm also a certified mediator at the Indonesian Mediation Center. And aside from the dispute works at this firm, we also developed the insurance practice group. This is considering especially considering my past involvement in life insurance company. So, in brief, we assist not just life insurance, but also general insurance companies. And recently, we also assist reinsurance companies. So it's a quite heavily regulated industry actually in Indonesia, and in most cases we have to liaise and make inquiries with the Financial Services Authority (OJK) in Indonesia. And probably another practice group, not just practice group, but also one quite recent practice of law is the data protection, because Indonesia just had the first personal data protection law back in 22, and it will take full effect October this year. So there are quite many inquiries on how companies should adapt, how companies should adjust their data protection policies and code of conduct and so on. So it's quite interesting new practice at the firm. Thank you. Okay, some of the most common concerns that would be the global trends in doing negotiation or resolving disputes, I think are the needs of the client to resolve disputes quickly and to carry on with the transaction, with the business or projects. That's one. And second, I think it would be the cost. Not just legal costs, but also any associated costs that come with resolving disputes. Yeah, the first, with quick dispute settlement. Okay, some actions, some alternatives to settle dispute do offer a quick settlement. Yeah, that you can resolve the dispute within certain quite brief time period. But probably it's not always. It doesn't always come with effective cost. So it could differ from industries to industries. For example, for mining companies, often they have to take whatever needed to defend, for example, their mining sites. Yeah, so and in many cases, negotiations may not work, and you have to take certain legal actions, arbitration, compensation, and so on, which may result in certain legal costs, for the companies to bear. But again, I think the time needed or the time spent to settle disputes, and the associated costs are, two important factors that many companies are considering. You know, what considering what action to take, how long will it take, how long we can bear this, how long could the legal battle be. I think what is needed for lawyers or negotiators are really to understand not just the client's industries, the specifics and particulars of their industries, but also what actually is the concern of the client. For example, if a project is going on, a long time project, in such a case, a quick dispute settlement may be preferable. Although if you go straight to negotiating, it may not always work, because the other party may not have the same the same intention, the same good faith to settle the case, and they just avoid obligations and so on. Yeah. So I think those two factors are important, for lawyers to always keep in mind. Not many companies are prepared to go full legal battle, or to spend about 3 to 5 years in court, to just to have final settlement of the case. That's so. I think those are the most important factors. Okay. One new law that I think it has quite big impacts on companies is the new data protection law, which will take effect this October. So in about 2-3 months, and the law provides 2-year adjustment period. So the last 2 years we've been receiving inquiries on how specifically companies need to adjust. Yeah. We noticed that the data protection law in some way may have been influenced by the GDPR. Yeah, because GDPR applies not just the EU states, but also companies dealing with EU companies. So one aspect of the data protection law is the requirement to have a data protection officer. Yeah, because the law is quite recent, and after it's being effective in October, some implementing regulations are actually mandated, required by the law to be issued. So also includes the regulation on the data protection officer. Who could be the officer, what skills or what requirements, what certifications are required for such an officer. It's been eagerly awaited, so companies can identify who could be the officer, because it can be an employee, a director, or it could be external companies also. So we can engage an external officer. So I think it's one of the recent laws that really is it has big impact on companies, and there are sanctions for non-compliance. So many multinational companies also in Indonesia are awaiting more technical regulations on the law. Okay, when negotiating, very often, we fail to keep the pace, and we are being carried away with the other party's pace instead. So what is important is we know our ammunition, and we know our arguments. We know what the limit that we can offer, and totally above that, we will say no. Another is, we tend to put on the table everything we have, but it's not always an effective way to negotiate. In some cases, we need to be sensitive and to know which card to put first on the table. If the other party say no, then we have another card that could help the parties when they when the other party do not really share the same good intention to settle the case quickly. For example, especially in the long-term projects, when like the project owner or the contractor are working together on the project, and they have conflicts. The dilemma could be whether we will get into this and spend some time to resolve this, and what will happen to the project, right? So the impacted party may want to, let's just finish this quickly, and I have this offer, do you want or not? But again, sometimes the wisest thing to do is to know how much you can bear, and can you consider to just cut the cost upfront, and then you can carry on with the projects. Often that's something that you need to consider upfront. Seeing young lawyers are interesting because they have so many passions, and they want to learn, and they just want to explore many things. Yeah. One point that I and the firm usually advise them is to do whatever assignments you're given, because from those assignments you learn not just legal skills, legal knowledge, but also how to deal with the case, how to deal with the clients, how to understand what the issue is really about, what laws would be relevant. From there, they can then see is litigation. Am I that passionate about litigation? Am I that passionate about arbitration, mediation, and so on? Or I'm more interested to exploring, corporate commercial or banking finance and so on. Yeah, that's one. Learning soft skills, and not just legal skills, but also soft skills are also important. Here in the firm, we have an annual youth program. We call it ALYP, Alcohol Youth Program, where we invite fresh graduates or final year students to join the program. The spots are sometimes limited, so interviews are really strict. Recruitment are also quite strict. The main purpose of the program will be to equip young lawyers, fresh graduates, with skills that usually are needed, required in working in a law firm. For example, how to do or to construct a due diligence report that can be digested easily by the clients. How to prepare, a power of attorney to go to court. How to conduct an effective negotiation and so on. Where while you are at university, at college, maybe not all these skills are provided. So at the end of the program, we usually assess them, and whenever possible, we offer associate position if they meet the requirements, qualifications. I and the firm, we are trying to help the clients with first ask them first what their concerns are actually, and how they really want to settle their conflicts. Very often clients are saying let's just go to court, or let's just report them to the police, and but then we try to advise them that this may take some time. Are you prepared to do that? Or this may some court costs may have to be paid upfront. Some arbitration fees will have to be paid upfront and may not be refundable later on. So if you are prepared, then yes, we will go ahead. Or for arbitration, for example, enforcement may have to be done in Indonesia. The proceedings, the procedures are in some are this way. You go to court, the relevant court, maybe in remote area and so on. Are you prepared? So in essence, we will advise them on what the procedures will be, on what costs may have to incur and so on. So they can consider. Consider, and then clients can make a well-informed decision, on what action to be done. The second question is how to mitigate. It's often advisable, even when you are drafting contract, negotiating contract and so on, to always anticipate that a dispute could always happen. And once it does, do you have an enforceable, dispute settlement clause? For example, if you want to go to arbitration, make sure you put the right arbitration clause. For example, if you want to go, Indonesia has some BANI, the Indonesian National Arbitration Center. If the parties intend to go there, make sure that the clause says so. Some arbitration bodies have recommended or standard clause, model clause, and so on. Make sure that those clauses are covered in the agreement. In some, having a well-drafted dispute settlement clause may help in a way when you got into a conflict or you have dispute.